when the time set just appears not to be enough. Ashamuelu now reminds us of the 2013 election petition that left different parties heartbroken.
Kenya's presidential petition at the Supreme Court is quite unique. And that's mainly because of the 14-day timeline set by the Constitution within which the court must hear and determine the petition. Few courts in the world have had a petition in just a fortnight, and the deadline set at each stage could completely alter the life of a case. Like in the 2013 petition, where Raila Odinga's 900-page affidavit had to be thrown out because it was filed after the deadline. But while Raila's petition only suffered a small setback, for others, time was the make or break factor. Mombasa's Suleiman Shabal, for instance, moved to the High Court to challenge Hassan Ali Joho's election as governor in 2013. Joho responded with an application to challenge Shabal's timing. According to the law, Shabal ought to have filed his petition at least 28 days after the declaration of Joho's win. The High Court, however, ruled in favor of Shabal, sending Joho to the Court of Appeal with his argument on timing. The case went all the way up to the Supreme Court, where the bench overruled the High Court and the Court of Appeal. The Supreme Court clarified that the declaration of Joho's election was on the day that the IEBC gave him his Form 38 and not on the day of gazettement as envisioned by Shabal's team, which meant that Shabal was too late in his original petition. The case between Gishuki King'ara and Mary Wamboi is another good example. Although Gishuki King'ara's petition to challenge the election of Mary Wamboi in Othaya constituency sailed through the High Court and the Court of Appeal, the Supreme Court struck off all proceedings from the two junior courts, citing that King'ara had filed his petition after the 28-day deadline. And then there was the case of Harun Lempaka versus Lemanken Aramat. The polls at Narok East constituency had placed Lempaka at second place, announcing Aramat as the elected MP by 441 votes. Lempaka filed his petition at the High Court asking for a recount of the election.
I am of the considered view that the results of the Narok East constituency were free and fair.
The High Court struck it off. But when Lempaka went to the Court of Appeal, the court overruled the High Court and ordered for the parliamentary recount. Aramat sought the Supreme Court's opinion. The issue of timelines came up again. The Supreme Court went back to the beginning and found that Lempaka had filed his petition at the High Court 36 days after the pronouncement of the results. He had gone beyond the 28-day deadline. This time, the court ruled that because the petition had been time-barred, the courts had no jurisdiction to hear the case in the first place. Perhaps one of the most interesting cases is the Waititu versus Kidero case of 2013. When Waititu filed his petition to challenge the election of Evans Kidero as Nairobi governor, his case at the High Court was unsuccessful. Naturally, Waititu moved to the Court of Appeal, but there was a spanner in the works. Waititu and his lawyer, Professor Ojienda, filed their appeal after the 2-month deadline set by the law. This was because the High Court had delayed in producing the typed court proceedings that Waititu required to move to the Court of Appeal. The Court of Appeal still heard Waititu's case and actually nullified the election of Evans Kidero as Nairobi governor. Kidero moved to the Supreme Court and through his lawyer Feroz Noji argued that Waititu's appeal was time-barred. The bench ruled in favor of Kidero, but one judge left a dissenting voice that still haunts the judiciary's administrative arm and earned her the tag, the Great Dissenter. Although she concurred with the rest of the bench's decision, Lady Justice Njoki Ndung'u felt that the courts had been unfair to Waititu because the issue of time was out of his hand, and that the court's administrative machinery left a clog of injustice for this specific petitioner. So, if the 2013 elections petitions are anything to go by, for a case to even get to the hearing stage, time is of the essence.
All right, time is of the essence, and we can now be joined by Bobby Mkangi, as I promised. He's a lawyer also, and was a member of the COE.
Yes.
The guys who, some people can say, came up, but I guess it was many people's ideas, but midwifed it, basically. Yeah, but the whole thing of time, actually, that's what we were discussing here with Kamodo Waiganjo, that it seems to be everyone's enemy when it comes to these kinds of things. And with specific, obviously, there are many cases there that we would not be able to go into, but with specific reference to the presidential petitions, we were trying to go through what informs this whole thing of 2 weeks. Like, what's so magical about 2 weeks? And now we're all saying we are filing these things up to 11:45 or whatever because we didn't have enough time.
Well, timelines, and it would be remiss of me not to apologize for not coming within time.
Yeah, I was almost filing an application for the body of Bobby Mkangi to be produced as you guys do in court.
But thankfully, I'm here. Thank God to have arrived. And yes, when you look at the strict times that have been put within our constitution, you have to examine the history of constitution making in our country, and particularly the mandate that we as a committee of experts did have. Particularly two issues of one, being constituted to complete the work that the previous constitution-making processes, the guy-led process, Bomas, the referendum in 2005 had produced. And with that, we had to be attended and conscripted to look at the documents, and especially the draft documents that
but what may have been the thinking behind the 14 days?
The thinking behind it, and that's why I had to go back to that history, because interestingly, the draft that we had to look at, the Bomas draft, the proposed new constitution of Kenya of 2005,
so-called Wako draft.
Yes, the Wako draft, actually, which were pronouncing the views of Kenyans, the views that Kenyans gave to the guy-led commission. Interestingly, what had been in those drafts were actually 7 days, not even the current 14 days.
Wow. Okay.
So you can see the appetite of Kenyans right from 2000, the views they gave to the guy-led commission.
To finish this thing quickly. And
yes, and when I was waiting, I had my senior explain the social, economic issues that Kenyans
but
think about.
Do you think that in light of all of these things, some people talk about hindsight, do you think that that conversation perhaps should happen post this, that maybe we need to have another conversation in the country about those timelines?
Absolutely. And again, Kamoto did mention that it came up last year during the Windsor talks, but it was set aside or actually appreciated.
For perhaps more urgent, more important issues.
or the appreciation was perhaps
less.
within these 14 days it was possible. Interestingly, Joe, this model that we have, the 14-day model, since we've devised it, Zambia has taken it up. They have a 14-day, although theirs is not well formulated because it says the Constitutional Court there can hear a petition within 14 days. Here it is here and determined. So, and Zimbabwe also, in their 2013 constitution, they took up this 14-day formulation. So
they're borrowing from
it
what
seems
we now
like
think is a headache.
Exactly.
But let me get to this, Kamodo, about this hearing and determining. Because as things stand now, how I understand it, tomorrow there's a pretrial conference, and after that, I suppose Sunday, the hearing proper, as it were, begins. That's less than a week, and by Friday, they not only should have finished hearing, but we need to know what they have decided. How do you do that? So what period do you suppose the judges have? What is going to happen? When are the lawyers going to give those oral submissions that we like to watch on TV?
The sad thing is that Kenyans will not enjoy the drama of the hearings and the back and forths. I think they would love that. But tomorrow they finalize with the interlocutory applications, and remember that before the hearing starts, the judges have to make the decision on those applications, because some of those applications have an implication on the hearings or when they start. I suppose they might start on Sunday. So there's still a number of steps to be taken before the hearing starts. That is the submissions, or the presentations on interlocutor applications, any responses to those applications, and the decisions on those applications. And then, of course, the pre-trial conference. Then the hearing itself by the lawyers is limited in terms of time. Lawyers, and that is where the lawyers are required in their submissions to be as concise as possible. And then you're given very limited time to expound. It is not to reread those. The assumption is that the judges will have read the submissions, and then now you just highlight those issues that are important. Remember that we must give sufficient time then for the judges to consider all this material and give to us a decision. Now, I've even had it asked that the judges must each individually write.
Yes, I'm going to ask that.
Now, you can imagine...
Like we don't want 3 minutes, 6 minutes anymore.
You can imagine the pressure that would put on the judges, because it would mean that the judges, each of the judges must then consider each of the aspects of that petition and make a considered decision on each of those issues. The way administratively it would work in a process like this is that you share out the work. Agree generally on broad principles, and then say, you go and now go and work on this area, you work on this area, and then we come together and have a considered decision together.
But they do have that discretion what to do with that file, whether they give us three minutes.
Or they can do that. They can actually do what is being asked. They can actually, in an ideal world, I think that would be good. The problem is actually a time issue. And I think that's what I'm saying, that we blame the judges. We ask of certain things of the judges, but we have not created the infrastructure for us to deliver in that respect. So if we really are serious that we want the judges to do a well-considered, and you hear what each of those judges says, then we must go back to the drawing board and say 14 days don't matter. 14 days are not critical. We need to expand them. If we insist on the 14 days, there must be a price we must be willing to pay. And part of that is that there are certain things that are not going to happen in the sort of intensity that we would have wanted. Yeah.
Bobby, you are dying to jump in.
Yes, I agree with Kamoto in that regard, that perhaps, every party in the petition definitely is constricted in terms of what they can furnish with us and within the process itself. But going back to the judges, I think definitely it will be very difficult, a huge challenge to consider that by the end of this process, they'll be able to come out and give us a full length of their reasoning as per all the issues.
So practically speaking, right now, if you're a Supreme Court judge, what are you doing now? I mean, there are all of these things that are flying around, but for you to say, now I'm ready for the start
I can tell you what they are not doing. They're not sleeping. They're not can't sleep for this week.
I think they're not sleeping, they're not watching us, which would be healthy, not reading the newspapers. I think they don't have time for that. But I would want to say, perhaps what is being requested of them this time around, instead of the 6 minutes that we got last time, even if you're going to get the decisions on each of the issues that are going to come out as of tomorrow during the status hearing to be determined, perhaps get an abridged version, the main points towards each of the verdict that the judges will have arrived at. Not just
and that doesn't have to wait for the lawyers to speak or whatever. They can actually go through all of these things and begin to make
No. They will still listen to the lawyers.
Yes.
But
I mean, but in terms of beginning to make some impressions of what is what, they don't have to wait for that.
The bulk of this case is in the pleadings and in the submissions. The lawyers will just come and amplify those submissions. So I imagine that right now, the judges and their researchers, remember that the law actually requires that they have researchers.
Yeah, actually, when we found Justice Maraga, he was sitting there.
They have researchers. In fact, by the way, from what I know of the Supreme Court, one of the saddest things is they have lost some of their best researchers in the last 1 year. And that is something that we must apply our minds to. If we're going to have a strong Supreme Court, we must ensure that the caliber of researchers we have is of the senior counsels who are going to appear for the respondents and the petitioners. Because if we're going to have this sort of time, you must ensure that the judges are actually sitting with their peers intellectually during this process, so that by the time the lawyers are coming to appear before you, you're actually even as a judge asking for clarification because you have understood what the case is, as opposed to be sitting back and you're hearing it for the first time when it is coming. So I think we must also determine what is the ideal infrastructural support for our judges if we want them to deliver what we're asking them to deliver.
But one imagines that at this point, whether at the status, the pre-trial status, whatever conference, that they say, so having looked at all of these things, we think these are the issues in this case. When do we get to know that this is what the judges will be deciding on?
It should be tomorrow.
At the pre-trial conference. That is one of the responsibilities of the pre-trial conference is narrow down the issues. Narrow down the issues so that the lawyers go and only respond on those issues. And number two...
Which can be contested or no?
No, what will happen, usually the lawyers will generally agree on the issues. And the ones that are contested, the court will determine. The court will say these are the issues. And then you'll also agree on timelines. How much time is each part going to be given? Are you, for example, you've got 3 respondents. Is each of the respondents going to be given the same amount of time? What time is the petitioner going to be given? Do you give their 2 petitioners? Do each of the petitioners get time, or is it a consolidated submission? What are the other? So there are it's issues about how is this process going to be carried out? What are the timelines? You have only if it's the respondent, you only have some. If it's amicus, how much time does the amicus have? And what are the issues that the amicus can address the court on? So those are the procedural issues that are agreed at the pre-trial conference tomorrow. Yeah.
So he mentioned amicus. I mean, given all of these things, how is the court likely to be prioritizing? Because Sophia was telling us how there are all these, there are 4 people who want to be enjoined, then the amicus, I think now is LSK, the AG, and surprisingly, Charles Kanjama. So how do you decide who you get to hear and you're all bombarded with all these things?
I think it also depends on what the applicants will definitely, one, you must have proficiency, you must have the status, and that must be proven, and also the issues that you're going to command or relate to the court, because you are coming to the court as a friend of the court, as a person who is going to provide information to the judges that is going to help them in arriving at a just decision after the process. So during this time also, all those issues are going to be prodded out. Who are you? Why do you want to be heard? What information that is so, unique that you bring to this process? And if it is found that each of the applicants meets this criteria, then they can be allowed or be given audience before the court. If not, then the court will decide on who will be heard.
Okay, Kamodo, the final word, 30 seconds. Does it matter that this time we have all 7 judges listening to this? Any material difference that might make, even if it's only academic, maybe?
It helps, because sometimes, I mean, in the unlikely situation or that there's a disagreement within the court, you want to ensure that you have an odd number in the judges, and that's why you have 7, so that then you can have a majority judgment. So that is why, but at the end of the day, in this sort of matter, it's always preferable. It's always preferable. We shouldn't aim for that, but it's preferable because of its implications that the judges speak with one voice. But it is not a necessity.
Okay.
Yeah.
All right. Thank you very much, Kamodo Waiganjo, Bobby Mkangi. Timelines. So we have to end it there. Remember, in the next few minutes, my colleague Betty Chalo will be bringing you the news update. Yeah, there she is, getting all ready. And in the next few minutes, she'll be coming up. Thank you very much for watching the Supreme Petition. Remember, tomorrow, the status conference, the pre-trial conference happens, and then it all begins from there. Do have a good night. God bless you.
An interlocutory hearing is a court hearing dealing with